Good afternoon, everyone. We will start the webinar. I can see some of you on the chat there. If you want to jump on and say hello to each other, that's fantastic. We can then see who you are and where you come from. My name's Dan Hooton. I'm the Managing Director of Spearfish Security. And for those of you who don't know us, we are a security risk management company specializing in international development operations. We operate across Africa and Asia in medium to high risk environments. And we provide a range of security services from risk assessments to training courses to embedded advisors in client operations around the world. Today, we're going to speak about duty of care. And the reason we think this is important is that it is usually the topic that triggers our involvement with clients as a security provider. And it's the requirement to look after staff properly when deployed in the field. We'll operate today under the Chatham House rules, in that you can use the information from the seminar today, but please don't attribute it to the person that has given it without their permission. We've spoken recently about how the changing models of delivery mean more remote teams, but there's still a requirement to get people into cities, regions, LGAs, and other site-specific areas. And the trick is to make sure that as your business model has changed over the last 12 months, your duty of care platform has kept pace with this. And even if you're deploying or engaging staff in a different manner, you must still apply the same levels of duty of care for those engaged on your behalf. And you must also ensure, from a liability perspective, you've met your legal requirements and you're not exposing yourself or the business to any unnecessary risks. We're very lucky today to have Adrian Powell from Prolium Law speaking to us, and more of him a little later. But the reason we wanted to have a lawyer present is to hear the legal arguments for effective duty of care. We also have the opportunity to present questions to him later on, which of course means some free legal advice, but it's a chance to discuss some contemporary issues that the industry is grappling with at the moment and to build some form of consensus from there. Firstly, some admin points. If you could make sure you're on mute, please. I think everyone is. Thank you very much. Video disabled to allow a better image quality. And if you're able to, go into your name on the chat box and just put in your full first and second name and organization. Very useful for those of us who don't know each other. Adrian will be speaking shortly to give his views on how he sees duty of care impacting our operating platforms. And after that, I will pose 3 pre-prepared questions to get the Q&A session underway, and then we can open up to the floor. We're aiming for an hour, but if we run over and we have some time up to 3:30, we can take any longer Q&A you might like to ask. And when it comes to questions, because we've got a large group today, if you can put your question into the chat box, I'll then select it and put it forward. And I'll try and get around everyone, but there is a chance that we've got such a large group, we may not be able to cater for everyone, but we'll do our best. But what I would say is we have a great group of people on the call, and you all have something to give, so please do dive in. Also in the room, we have some of the Spearfish team from the UK, Darren, Lucy, Neil, Louise. And we also have some of our regional security advisors from across Africa and Asia, and they'll be chipping in as well. So then, let me introduce Adrian, and we can get the session underway. Adrian Powell is the managing partner of Prolium Law. He has extensive experience of providing a broad range of commercial, corporate, criminal, and regulatory legal advice in both the UK and high risk and complex jurisdictions around the world. He qualified as a solicitor in 2004, following 11 years in the British Army. And after several years in general legal practice, from 2006 to 2013, he spent the majority of his time in Iraq and Afghanistan as a legal advisor with various entities, including the US Department of Defense, a major private security company, and the UK's Foreign and Commonwealth Development Office. And from 2013 to 2015, he managed a significant legal project focusing on war crimes in Syria. So on that note, Adrian, the floor is yours.
And I'm a solicitor in a UK law firm called Prolium Law, commercial corporate law firm, but we deal with many industries, including the security industry, development industry, insurance, and increasingly the cyber world as well. We are often deployed into the areas that you may well all be working in, and we currently have 2 members of staff over in Kabul giving legal advice to a client. So this is nothing new. Purpose of today's talk is to look at negligence and in particular duty of care, but I should say this is in respect of the law of England and Wales. So as will become apparent throughout this talk, hopefully, the jurisdiction where you base contracts, where you decide to operate from, are always important. You should always be cognizant of that. So generally speaking, under English law, if a company is sending an employee somewhere in the course of their employment, the company will still owe them a duty of care, even if they've given that employee to somebody else to look after, such as a security company or what have you. Your duty of care is still owed by the employing company. And today, hopefully, we'll give you a better understanding of the duty of care. And so you are going to be getting a free law lesson, as it were, but there won't be any questions at the end of it. We often hear there's a lack of understanding about precedents in cases and how the law has developed over the last 5 or 10 years, or even over the last 20 years with the major conflicts that have been going on around the world. And hopefully we'll give you some understanding of them. Quite often these cases are settled out of court, so it's difficult for you to understand them, but we do. Sorry. So the duty of care essentially forms part of the law of negligence. And for your understanding comparatively, this principle of law, negligence, or avoiding negligence, if you might, and duty of care, it is prevalent throughout the world. And just for some understanding there, you can see comparatively, we've listed the laws that for Sweden, Italy, Germany, Spain, Portugal, Austria. Just so you understand that this is not just something that's particular to English law, it's worldwide, including America, including states within Africa. So please do understand that we're not just talking about English law in isolation, but a lot of the understanding about duty of care does quite often stem from English law and sometimes French law, and there's similarities there, as you would be able to see if you were studying it. From the English law perspective, a duty of care, there are essentially 2 approaches to duty of care. There's the statutory and then the common law. The statutory might be something like health and safety regulations at work. And that would be very prescriptive. It'd be very clear that if you are doing A, you must ensure the standards of B are put in place. Whereas when it's a little bit less certain, we fall back on what we call the common law. And this is where the term, the duty of care, comes from. So it forms part of the tort of negligence. I won't go into that because it's a bit too heavy, but essentially we're looking at when negligence, or the tort of negligence, is where there's a wrongful act or an infringement against somebody leading to a legal liability. So in the sense of what we're talking about here, you might be able to put some of your own context and experience into place. Someone gets injured, an employee gets injured in the course of their duty. They want some sort of compensation or understanding as to what's happened. And this is where, under English law, the tort of negligence comes in. This gives them the avenue into this. And equally, it gives masses of guidance into understanding from an employer's perspective how you can do your best for your employees and do what you're legally required to do for your employees. It's a very misused term, and duty of care, and it can quite often end up in a situation where people twist it in their own minds, not deliberately, and it becomes confusing. So we'll try and give you a better understanding. If someone brings a claim of negligence in that there was a failure in the duty of care, they're under English law, they're required to prove all of the points that I've listed on the PowerPoint there. And it's very important to understand how these break down, and we will break them down a little bit further on in the talk. But the 3 points are that there was a duty of care was owed. So there was a duty of care owed from an employer to an employee, because it's not always the case when it, depending on the type of employee you have, where they're employed, how they're employed. But generally speaking, that's one of the things they're looking to show, that there was a duty of care was owed to employee to employer. Next thing is that there was a breach of that duty of care. And then, as we come on to later on, if there was a breach of that duty of care, then it needs to be something that was reasonably foreseeable. And the way we sort of do that is, we all hear the term hindsight's a wonderful thing, but essentially, when you look back on situations, quite often you find, well, of course, that's what we should have done. Of course, that's what we should have said, and how we should have acted. But it might not always seem the first way to go about things. But from our perspective, you hopefully be able to, at the end of this, understand that the reasonably foreseeable thing might be a little bit more simple than just saying, well, yeah, apply a bit of common sense to somebody's safety and well-being. And then the next point is that the loss or injury was caused by that breach, because you can't have a situation when somebody's got an injury, but it wasn't actually caused by something you as an employer did or didn't do. And then often, as is important, you need to understand the thing called contributory negligence. And that's what maybe in this situation the employee does that was not particularly clever in the first place, and contributed to the situation they found themselves in. So I know this is quite heavy, but hopefully it's all going in. Now, we'll go back and sort of break down those areas a little bit more. And the first question is, was a duty of care owed? In some circumstances, it is automatically owed. So under English law, if you employ someone as an employee, they've specifically got a contract of employment, then employer to employee, is a duty of care is automatically owed. It's the same from a teacher to a student, a road user to another road user, manufacturers to consumers, doctors to patients, and lawyers to clients. Automatically, a duty of care is owed. So the point being, if you are all employers or involved in a process where you're managing staff, you should be cognizant of whether or not you owe a duty of care and who you owe a duty of care to. It's not automatic when it comes to using consultants. And this is something we see in the private security industry a lot. There's an awful lot of use of consultants. But essentially, the case there, Lane v. Shire Roofing Company, says that the more dangerous a situation gets when you're employing a consultant, the more likely it is that you owe them a duty of care. So what does that mean? Well, it means don't employ consultants in the middle of a hostile environment and presume you don't owe them a duty of care because they're a consultant. English law will certainly look to say, well, you probably did. Next question, was there a breach in that duty of care? So this is very complex, and you'll see there is areas such as, was it reasonably foreseeable? But you have to apply a test to it. And the test has been described in many cases as, was there a failure to exercise the care that the reasonably prudent person would exercise in like circumstances? And you have to take that comment and that line and say, well, how do I apply that to my company? And if you're employing somebody in the middle of Kabul to go and do a task for you, you have to say to yourself, well, what does in my circumstances, what does the ordinary, reasonable, prudent managing partner of a law firm do in a situation like this? Well, for me, that, because of the experience I've got, it becomes common sense. So we use a private security company. We ensure our staff are trained when they go out there. They've got the ability to make calls. They're insured, all of that type of thing. And they've done heat training, or they're up to date with their heat training. But that might not seem automatically obvious to a lot of employers. But that is the test that will be applied to you. And just because it doesn't seem obvious to you, it doesn't mean that a judge won't think it was obvious to him or her in court one day. And reasonably foreseeable. What happened to that employee reasonably foreseeable? Well, it's probably and I'm using quite extreme situations here, reasonably foreseeable that if you go to the middle of Kabul right now, and I'm using that situation because I've got staff there, that there is a likelihood that if they went out in a car, there'd be a VBIED, a vehicle-borne bomb, if you like. They would be at risk of that. So if they did get injured by that, was it reasonably foreseeable? Yes, it was. It might not have been necessarily reasonably foreseeable that they would fall downstairs, as you will see later on, and really seriously injure themselves, although a small risk nonetheless. But it's all about what is reasonably foreseeable for the situation you're putting them in. A really obvious example, as you already alluded to, is don't send someone to a really difficult place and not give them a set of body armor or give them access to a set of body armor. You might be asking for trouble there. Less obvious might be sending a student to an education facility in the United States. And you'll recall there was a serious series of shootings in the US up until certainly when COVID kicked in. And then 2015 to 2018, there was 84 students shot during incidents in universities in the United States. We've given this talk to universities before now, and that absolutely raises people's eyebrows because they just don't think that that was something that was reasonably foreseeable. Well, if it's going on and it's happening, it's reasonably foreseeable. And then the next part of it, as you might recall, is was the injury loss caused by that breach? So if somebody brings a claim against your company, they have to show that as a result of you having a duty of care, and there was a breach of that duty of care, that their injury was caused. And it really is important to be certain that you could end up with a situation where somebody is in hospital, they've had a car accident, but they're in hospital, but the actual reason they're in hospital is nothing to do with the fact that they had a car crash. Not the best situation, but I'm trying to understand you, from an employer's perspective, how you need to look at these issues. Was their injury caused as a result of something you did or didn't do as an employer? And that last point there, the true cause of the claimant's loss was something other than the defendant's carelessness, and this is contributory negligence. You put an individual in a difficult place, and they decide to run across the road in the middle of Baghdad in a busy rush hour and get run over, and they try to bring that claim against you that you were somehow negligent as the employer. Well, probably not, because you didn't expect them to run across the road and get run over. Sorry, that's just clicking on a bit quick. So some cases now to give you some understanding of how cases can twist and fall on certain facts. Dusek versus Storm Harbor Security. So Dusek was employed by Storm Harbor, goes to Peru and uses a remote site and takes a very risky helicopter ride above safe operating altitudes. The helicopter was arranged by another company that Storm Harbor was in partnership with. So trying to explain to you now how you as an employer send somebody somewhere and somebody else becomes involved in that person's safety or that person's activities. The flight crashed and Dusek was unfortunately killed. So the question was, well, did the scope of Storm Harbor's duties and duty of care as an employer extend to the charter of the heli-fight? And in this particular sense, the court held that Storm Harbor was liable for Dusek's death, even though Storm Harbor didn't arrange the flight. And why was that? Well, it was reasonably foreseeable that there were dangers involved in such a trip in a remote access location in Peru. And reasonably responsible employer would have realized that there was a need to fly in a helicopter, and so there were significant risks. And they were therefore required to make some form of risk assessment. And so there was a duty of care owed, and Storm Harbor caused that breach of a duty of care. The big thing to take from this is make sure you have policies and you have risk assessments in place as soon as you start sending staff to people, to locations overseas or into locations where it's more dangerous, or giving them tasks that might be likely to be more dangerous. You must have policies and you must have risk assessments. It's the first thing we would ask if we were bringing a claim against a company on behalf of a client. We would want to know where your policies are, and we want to see your risk assessments. And if you haven't got them, you really are in a sticky position. If you have got them, you're already halfway there. It is a huge positive. So this next one, CASI versus GMP securities. So this is again about, you've got a member of staff living and working in the UK, but you send them overseas. So CASI is employed by GMP, and there's a partner company, Sundance, who arranged a visit to a mine in Congo, and again involves a charter flight. Sundance, who's the partner company, says they would use JetFly but changed to another provider in the last minute. First one's a flight, but the second flight, everyone's killed on board, unfortunately. GMP say they weren't made aware of the last minute change of the carrier, but considered that the flights were relatively low risk anyway and routine flights. So in this particular case, GMP weren't liable because GMP could not rely on Sundance to do the risk assessments anyway. It was still something that GMP needed to do. GMP took no steps to satisfy its duty of care to CASI. They should have done something. They should have checked with their risk assessments, therefore in breach of duty to assess risk. But even if they'd have made an inquiry, even if they'd have done a risk assessment, they probably would have said fly anyway. And this gives you the idiosyncrasy of how these cases twist and turn on the facts of the case. So this one, even they didn't do it, they were absolutely liable for his duty of care. There was a breach in the sense that they didn't do it. But the fact is that even if they'd have done it, it wouldn't have made any difference. He would have been killed anyway. A question we get asked, is the employer liable when an employee goes and does something else on their own during a leisure time? Well, they might be, they might not be. And again, the point to understand is it just turns on the facts of the case. So in this particular case, a soldier's on a sailing trip overseas. He decides to go off and have a swim on his own. He dives into the water, strikes his head on a sandbank, and ends up quite seriously injured. During the claim, they tried to make out that he was keeping fit as part of his employment, but the point is he went off and did his own thing. Quite relevant within the military circumstances, because you don't go off and do your own thing without permission. So in this particular case, the UK Ministry of Defence wasn't liable because if he swims outside of the scope of his employment, there's no liability. This is not the best case in some respects, because if you send somebody to this is a adventure training trip, but if you send somebody into the middle of Baghdad and you put them there for a particular length of time, the chances are the court would take the view as well. You put them there for a long period of time, it's not as if they could go walking around. So it might not be the same situation. Another case here, an employee of a UK company goes to West Africa. While he's there, he contracts malaria and he unfortunately dies. Prior to leaving, he was advised the employee by his company to seek medical advice regarding vaccinations. He said he understood, but he didn't do it. And his widow brings a claim for damages against the employer. In this particular case, the court decided that the employer was liable because it had a minimum responsibility to ascertain and make available employee publicly available information on health hazards. In all of these types of cases, you can see that as soon as you start moving staff around, you need to think about their safety a lot more, and you need to think about what you should be telling them as a matter of course. Then there is the next sort of example of cases where an incident happens in one case with one country, and there's a particular entity and brings a case against another entity in another country. And this is about when you might have subsidiaries. You're a UK company, for instance, and you have a subsidiary in Nigeria, in other parts of Africa. You have to be really cognizant about the sort of potential for problems coming back and how you set that company up. Vendetta Resources PLC, listed company. Konkola Copper Mines, Zambian company, operates a mine in Zambia, and its parent company is UK registered Vendetta Resources. Group of Zambians bring the claim for personal injury due to pollution. The claimants managed to get permission. So remember, this is being brought from Zambia into the UK courts, and they got permission to bring the claim over in the UK. And it was taken to the Supreme Court, which upheld the decisions of a previous decision. The court decided, and this is about jurisdiction, there was a real issue to be tried against Vendetta, the parent company of KCM, and that the UK courts had jurisdiction over a case, even though it was outside of the UK. So the point being is, please ensure you understand where and how your liability sits, not just from an employee perspective, but also from a corporate liability perspective. And again, this is another example. Unilever, claimants were the victim of violence in 2007 in Kenya. Claim was brought the claim against Unilever for failing to offer sufficient protection to its employees. Now, this is slightly different in that the court decided that Vendetta was the decision that they were following, but they said there wasn't a strong enough link between the claimants and Unilever. Now, you might say, why is that different? But this is the point, is please ensure that you understand where your corporate liability sits and how strong it is and the link it is, and also consider how not just that, but also your employer to employee, your almost individual level of liability sits. So consequences of potential failing to understand this particular area of law. If there's a death of an employee, expect under English law there to be a coroner's inquest. If there's a coroner's inquest, you can, and depending on what the decision of that coroner is, you might find that there's then a criminal inquiry, or indeed a civil claim is brought, or indeed the coroner's case might be such that it concludes in a way that there's no further realistic action to take, there's no liability. Certainly in England, there is also the risk of criminal prosecution for corporate manslaughter under the Corporate Manslaughter and Corporate Homicide Act. So this is again corporate liability. Possibility of criminal prosecutions for gross negligence as well. And then of course the civil claim for negligence through the courts for injury, loss and death. The point being, you can be hit at every angle, so understand this. And then there's a reputational damage fallout from all of that as well. Some quick points on duty of care and COVID before I finish. How does this relate to coronavirus? Well, as yet, there's no precedent been set on this. And I think rather than sort of dig into this in any great level, you've got to be thinking about where you're sending your staff and what you're doing with your staff. It might be that you've decided not to supply basic hygiene facilities in your place of employment for your staff. And there is some suggestion that you couldn't necessarily say that they were contracted COVID-19 whilst they were in your place of work. The point being is, don't think it is going to be a situation where these types of cases aren't going to crop up, because they probably are. So do what you can now to minimize this type of claim coming your way. Out of court, most cases get settled out of court. And what that means is they probably don't even get to court. They are settled by way of the exchange of information between the lawyers, because it's expensive to bring claims and defend claims. Don't underestimate just how expensive it is. It's in, as minimum 5 figures for a reasonable case, and they're the costs that the lawyers take as well. thinking about this now will more than likely save you problems in the future. Quite often these cases are not reported, so you don't get to find out about them unless you can get that knowledge imparted by lawyers who can sit there and explain to you certain situations that happened that are similar to yours. And these are going on all day, every day. So don't think your case is unique. I do advise you to have a chat with a lawyer. So key points to take away for you. Employer must make its own assessment of risk. You can't get rid of that risk as a problem. It is your problem, remains your problem. Unequivocally, have policies in place to approach any of the issues we raised here. Ensure you have risk assessments in place. That's what security companies are very good at. That's what Spearfish will help you with. But just remember, just because Spearfish do it for you, it doesn't mean that if it goes wrong, it's not your problem. It's still your problem. If you're moving people around, not just a case of moving them within UK, if you're moving people to other countries, adds a new dimension. The duty of care is owed. Be very clear. If somebody's driving from London up to Chester, yeah, is there a duty of care owed? Yes, there is. But is it likely to be a problem for you if they have a crash? Possibly not. But as soon as you put them into more difficult places, it's going to be your problem. Ensure you have insurance in place and ensure the insurance is fit for purpose. Read the policy. A lot of people just don't read it. We're seeing cases increasingly accepted by way of jurisdictions in the UK. Whether this is a consequence of Brexit and the courts trying to ensure that the UK remains relevant, we don't know. But there's definitely an increase in the amount of cases being accepted, whereas previously you might have said there's no jurisdiction. And above all cases are decided on individual facts. And hopefully we've explained that to you today, that what might be one case might not necessarily be the same as another, or it appears on the surface the facts to be the same. And that's it. You can now ask any more questions you want to. I am available.
Great. Okay. Thank you for that, Adrian. Apologies for the technical glitches we had throughout your talk, but we got there in the end. And also, apologies for the sun. I mean, it's so rare that we've seen it here in the UK for the last few months. I think it's taken us by surprise, but it's sort of slightly washed you out a bit. But we can hear what you're saying, so that's the major benefit. So look, I'm going to move on to a few questions now. But two things that really jumped out at me from your session just then is the word reasonable. You mentioned very early on, what can we reasonably expect to do, and how do you define that? That's probably a subject for debate. And then secondly, it appears that duty of care can be very subjective. And my response to that would be, well, if you define very clearly what you're going to do and how you're going to do it, you're taking the subjectivity out of it from a third party. You're saying, look, this is what I want to do, and I've done it. So you're almost setting the parameters, if you like, of your own duty of care without letting someone else, dare I say it, a legal investigation do it for you. Okay, so a question, my first question to you then, Adrian, how would you comment on duty of care trickling down in the contractual relationships, i.e. from the funders or donors through to an implementing partner and then their consultants?
Yeah, so what we've seen when the Foreign Office or the CSSF put out tenders for companies to supply capability is they make it very clear that they don't owe a duty of care to the company who wins the bid, but they also make it very clear that they expect the company that wins the bid and delivers that capability in the development world or security world or whatever it may be, that they will owe a duty of care to the people that they employ. And the FCO, CSSF, look for that in their bids. It's always been something that I've been raised a small eyebrow at as to how they manage to think that they don't owe a duty of care, but they do. And contractually, that's where they get round it, is by saying it's very clear that when you take it on. So the courts would pay attention to that. But essentially, if donors are in any way sensible, and most of them are very acute to this now. They are saying that there's no duty of care owed between a donor and an implementer, but the implementer owes the duty of care to its staff, to the people who it's working with, and the donor looks for that. That's what I am seeing.
So then the complication comes in if you are, say, the lead implementing partner in a consortium. Perhaps you've got a local partnership with a company, perhaps in Nigeria. The question then becomes is, how far does the duty of care trickle down to the local partner, and how do you define that between the two parties?
Could you define it contractually is the only way you can really do it. There are certain things, certainly under English law, you can't contract out of. So causing a death or causing a very serious injury or fraud is another thing you can't contract out of. But you can implement, if you have any thought that you think that you owe a duty of care, it's going to come back on you as an implementing partner. You should ensure that your contract with the people who are implementing on your behalf, and I don't mean from the donor's perspective here, I mean from probably people who are on this call, you should absolutely make sure that contractually it's very clear what's expected of you. And you're going to need to make sure they do what you do. And this is the whole monitoring and evaluation piece that comes in. Monitoring and evaluation isn't just about making sure that they deliver, excuse my flippancy, they deliver this creation of this water supply. It's making sure that if they're doing it in the middle of a conflict zone, they're doing it with an eye to duty of care, and that there's something going on. So, because you as the winning bidder, as it were, from the Foreign Office, are going to be looked at as the source of the problems if it does go wrong, and you haven't put adequate safeguards in place to ensure duty of care does flow down. But again, where you want to limit your contractual liability and where the law permits it, you should do it, is the point.
Okay, so essentially what you're saying is the devil is in the detail, and a thorough review of contracts on day one is really the best approach to start with.
Absolutely.
Okay, fine. Okay, my second question is, and it's linked to this, how do you draw a line under this liability that we're talking about? And two examples I can give you would be limiting the exposure of local partners through robust mitigation measures, or the law of unintended consequences. You have a truckload of equipment that gets hijacked by a local militia. It's then sold and used to fund their activities. How can you protect yourself in those two situations?
How can you protect yourself? Can you just ask me that again?
Yeah, sure. So limitations of liability. How can we limit that to ourselves? If we're engaging with a local partner, or if we are, for example, having a truckload of equipment that might be used in the conflict zone that's then hijacked and sold for profit and used to fund a local militia or armed opposition group.
Well, again, with local partners, you should limit your liability contractually where the local law permits. And if a local law is silent on it, you should take best practices from, say, for instance, English law. That's always going to be the best approach. And that's why, if you've got in-house counsel, you can, they will be looking to do that for you. In respect to situations where there's something that's beyond your control, if it's beyond your control, it's obvious it's beyond your control. If you've had equipment stolen and then falls into the hands of militia and they start using it in a terrorist campaign, an insurgency campaign, I wouldn't say ignore it. And we do have situations where we advise NGOs who are giving assistance to families of so-called terrorist organizations. And the question then is, do they fall foul of counter-terrorism legislation? Well, they could do, but they have to be very clear. But what we've had to do in the back is work back what's going to be the likely outcome by way of a prosecution. And quite often we find that it's unlikely there would be a prosecution. because it depends on your conduct, and trying to help people who are disadvantaged by family situations in Afghanistan is no different than helping people who are disadvantaged by domestic violence situations over in the UK. So you try and draw a parallel there, but it doesn't mean your staff should absolutely arbitrarily throw caution to the wind. But if you did get the situation whereby you had equipment stolen and it was fallen into the hands of insurgents or terrorist organizations, I would be notifying authorities that it's happened, because yes, you don't want to be seen to be in any way complacent or cooperating with terrorist organizations. I hope that answers the question.
It does. And just to reiterate that first point that you brought out, when you're reviewing your contracts from a duty of care perspective, it's not just the international view or perhaps the country of origin, for example, UK, US, it's also the local view of the country that you're operating in.
Yeah, 100%.
Okay, great. Okay, and then my last preloaded question is the implementation of duty of care. Any tips on how best to maintain that implementation throughout the life of a project or a contract?
Well, just to link up with a question from HP to everybody at the bottom of there, it says, generally donors don't fund security. How to fulfill the duty of care under such circumstances? The duty of care budget is most often absent. I don't agree with that. Duty of care should flow throughout all of your operations, throughout how you do everything. No one is saying that duty of care trumps technical capability when you're setting up a communications system in the deepest, darkest Congo. No one's saying that. But what we are saying is that if you've got good systems to set up that capability in a difficult place, you'll have duty of care flowing through your operational capability. And we've been to the full extreme as a law firm, to small companies, to very, very big companies, to NGOs, to unincorporated entities, to try and assist them with how their processes work and their processes flow. And the bottom line is, have policies and follow your policies. You will be utterly exposed if you don't follow your own policies, and even more exposed if you don't have them in the first place. A set of policies are the thing that will, to coin a phrase, keep you out of jail. Please do get them, and if you don't have them, you are absolutely looking for trouble.
Okay, and again, one thing that jumped out at me from the start of your presentation were A, the policies you just mentioned, but also B, the risk assessment prior to any project or implementation or otherwise. Okay, so thank you. I just want to open it up to the floor now, and perhaps we can build out on HP's question. So I think what HP is saying is that generally donors don't fund security, and how to fulfill the duty of care under such circumstances. Adrian, you're saying that isn't quite correct. You need to build it in and flow from policies downwards. Have you faced any challenges people have in terms of budgeting for duty of care?
I think it's not so much the challenge they face from a budgeting perspective, it's their approach. Quite often, people within this world, this industry, are very task-driven. They want to achieve the aim of what their ultimate deliverable is. And it is much easier to prepare that and process that process with a set of policies that guide you to that eventual. But a lot of people have missed it out. And that's what we find is when we deal with these sort of inquiries, we say, well, what shows your policies on this? And they're just not there, or they're just not taking the time to flow them into their process and using the right words. And then even when they do, and there's reference to ISO standards there, and I've been in the unfortunate situation where I've investigated deaths on behalf of corporations in places overseas. And what you find is that they can have every ISO that's possible to have, ISO standard, and they forget the pink element of what they're doing, the human element of what they're doing. And it's great to have these policies, but the people on the ground go, well, we know that management do this, but we don't really see that flow down. And management say, but we've got all these policies, why aren't they following them? We've got all these, ISO standards, why aren't they following them? And it's because it becomes a lack of communication between the workers and the management, for want of a better expression. And if they don't get pushed down and constantly flowed down, then the problems will start. So I would say rely on your own policies way before you start relying on ISO standards. Yes, ISO standards are great, but have your policies in place.
Okay, and make sure they're implemented.
Yeah.
Okay, and just really to add some personal experience there, and again, this is to HP, what we've found is if you can identify a mechanism to clearly articulate and ring fence a budget for duty of care or security, and it's presented in a logical and thought through manner, then generally it becomes an accepted part of a budget for a donor's program. So I think it's in the way that you articulate it, and it's the way that you try and split it out and clearly identify it within your other costs that then makes it something that you can actually build into your program or your project. We've had a number of clients who have built this right throughout their business model, and it becomes an accepted part of their bidding process, and it does work. And I think just to have any form of security budget, even if it might be on the lean side, is far better than trying to win a project and then cover security from overheads or management costs, because that's where the internal matches start and things just don't get signed off and approved. Okay,